Okay, so maybe it's time to ask, pause to reflect, to see if anyone else have some questions. Please.
In this world today, where it's relatively easy to produce apps, and it's really quite hard to get users. So how do you value users? I mean, WhatsApp, what's it make you money? But Mark Zuckerberg, how much? $17 billion just for the users. So how do you value that?
I think users become one of our, what we call customer lists, or what we call in trademark, we would say goodwill. You know, how would you say a trademark of Gucci worth more than, I don't know, 100 million? Why? It's just a design. I think it's the goodwill in the marketplace. So again, a lot of apps are offered free, as a matter of fact. So why they offer 40 million to buy or 70 million to buy an app? I know someone who created an app, sold to a Japanese company for 45 million. The reason why they were sold is they have so many users, that means market traction. There are so many users that you can offer them in-app sales, offerings, ads, presence, everything. So it's always the potential value it has. That's what my simple answer, but obviously VCs might have more answers.
So how's the patent only product? You know there are tons of different products out there.
Yeah. Patents, how are patents well, in theory, if you want, actually there are accounting firms do the traditional, which I put it earlier, quantitative methodology. They would put numbers, but nowadays a lot of companies basically, you know, a few on the marketplace, intellectual ventures, for example, they invest in patents. And RPX, these are all the big American firms. They actually are heavily investing in patents. The value they give to a patent, they don't go through those processes anymore because it's very costly to hire big four accounting firms, and it's very slow. How they value is they actually bundle them. If we're talking about big portfolios, they bundle them because a lot of claims overlap, and with more claims, you can also basically cover more products and cover your competitors' products. So patents are valued more and more as a portfolio. Sometimes number of claims can be factored into consideration, and also the independent claims, if I may just talk about patent claims, there are independent and dependent claims. Independent claims are the most novel and claiming the most innovative feature of a technology or innovation, an invention. So if there are, you know, the number of claims obviously is a factor, and the quality of the claims, broadness of the claims. So if you have a claim, you can only cover Android wireless phone, but you cannot cover iOS operating system or other operating system. Your patent is much more narrower. But if B has a patent that covers all kinds of operating system, including you know, desktops, then his patent is much more higher value than yours. I don't know if I answered the question. I think you still have some doubts. I think we can go into detail of patent valuation.
Would you put domain names under trademark?
Actually, you need to register both.
Yeah.
So if you have a trademark, and you can also register a domain name bearing that mark. But
but for IP asset,
yeah,
you didn't have domain names on that as IP property. You just classify that under trademarks as the unique.
I cannot. Yes, I think
would
so.
You add it as a separate class,
I think it could fall under, but domain names we don't normally categorize. But I guess it's an IP assets.
They have huge value.
Yeah,
I buy and sell domain names.
Yeah, you buy and sell domain names.
Yeah.
Oh.
I just hold one to Intel.
Wow.
Yeah, but I mean, and then as you know,
Is it a
the
good
trademark
business?
holder can go out to the domain name
Yes.
with UDRP.
Yeah. Right.
Yeah. So I was just wondering, as a piece of this pie, I think it'd be interesting to talk about.
Because domain names has itself, it has the enforcement. You go to the DCRP or the
You file a
domain name.
UDRP, but
Yeah.
I can.
Right. So it has its separate. Interesting. I need to verify.
Yeah,
I think I don't do a lot of domain names, but
Yeah.
it could be an IP asset as well. Yeah.
Yeah.
It's enforceable. Is it enforceable?
Yeah, I mean, they file lawsuits. Usually, it's a procedural thing
Yeah.
where they go to arbitrators.
Yeah. So it
But
should be under. But your domain name, you can only enforce it if you have a trademark, and it's a famous mark.
It's murky. It's really
You
murky.
cannot enforce your domain name rights if. So let's say my last name is Lee. If someone registered Lee.com, I have no rights to ask them to give to me because it's a generic name.
Well, for the sake of example, the Kardashians, right? So
Yeah.
Kylie Jenner and Khloe Jenner just got their name. Yeah, it's interesting. And the thing is it goes to arbitrators. And the arbitrators are international.
Yeah.
So sometimes, literally, they'll hand the domain domain over to somebody who claims they have a trademark or got a trademark post-registration.
Right.
And then I would have to sue to get my domain name back. That
Yes.
was illegally or
Right.
wrongly
But
taken.
first of all, you would have to secure your trademark first.
Well, and that's a murky issue because if you
Otherwise,
just said,
you have to be
yeah.
a very famous person. Like if someone registered Obama.com.
But if your name is Obama and you got it in 99.
Yeah, exactly. That's what I'm
Yeah.
saying. That you have to secure first your federal given or legally given rights, which is the trademark rights. Then you can ask for the domain name to be only. You are the only one who has such a proprietary rights. Otherwise, you don't have a proprietary rights, right?
I don't want to. No. Because anybody in here, I'm sure many people in here own domain names.
Yeah.
So the issue is companies now
Yeah.
are registering a trademark.
Right.
But I registered a domain name 10 years before, and if you go on domaining.com, you'll read case after case of this.
Yes.
And it's called reverse domain name hijacking. So you don't necessarily need the trademark to have legitimate rights. This is first use, and you register it. So, but some cases do what you're saying. If there isn't an existing trademark, they'll get a trademark and try and steal it, and sometimes do
Yeah.
steal it. So it's a huge, they're huge
Yeah.
assets. I mean, Facebook bought FB.com for $6 million.
Right,
Sex
right, yeah.
Sex.com was
I think they
20
should,
for 12.
yeah, maybe that chart should be revised
Yeah.
now. So, but I think I understand and I agree that if you already registered a domain name
Yeah.
5 years or 10 years ago, and subsequently someone else registered a trademark coincide with your domain name, then that person or that register has no rights to claim the domain name unless they offer to buy.
It's really murky. It's real slimy too, because then they start claiming that when you renew it, you had knowledge and it's bad faith usage. It's a very interesting component.
Okay,
very
they
important
can always
stuff.
claim. There are many people who like to claim a lot of rights, but
Yeah.
whether the law will grant such rights is
Yeah.
subject to,
Yeah.
you register the trademark later, maybe after you saw that name.
Yeah.
But then at the first place, if this person the entity registered the name 10 years ago, the domain name, why they didn't register a trademark?
Because a domain name is $10, $10 US.
Well,
and a trademark
that
is
comes
$1,200
back to
US.
the other question, startup question. What is more valuable? Is it your, I mean, domain, assuming domain rights is IP or intangible assets, proprietary rights, I have to say it's proprietary rights, such as know-how, such as process, business methods. Sometimes they cannot be patented. So when you have a very significant domain name that people out of 5,000 miles away can learn about it, why you don't register a trademark to protect?
Well, it's an expense thing. I mean, the huge difference between $10 and $1,200 in the US at very, very cheap with an independent.
Register a trademark is not 1,200.
How much?
Our firm does for a few hundred.
Really? Wow.
Because it's electronic process.
Yeah.
We have even registering or filing a patent application, we actually reduce the process by, we give you a format, you fill it out first. Well, obviously we have to write a application for each inventor, but we kind of simplify the process. So it reduces the time attorneys have to sit and talk to an inventor.
Yeah.
Years ago, we have to travel to meet inventors. Nowadays, rarely we need to travel to meet inventors unless we need to see the prototype, unless we need to look at the actual machineries. So it's not the old days of big law on Wall Street or in Central anymore.
No, I do agree with you. There are a few that there's one that I own, then Apple started using the term.
Yeah.
No trademark. I owned it way before they used it. I was going to file for a trademark, but they filed for it. But I own the domain.
You own iPhone.com or something?
No, it's WatchKit.com, which is their software platform for the Apple Watch. So I'm half expecting them to come after me, but
Okay.
I could argue it and probably win it.
Wasn't there a problem?
It's
Apple
hard
have to pay
to-
someone like for iPhone.com or something?
Yeah, all the time.
Millions or something.
Yes.
Yeah, because there was a guy in Brazil that had the trademark for iPhone. China iPad, they had to pay $60 million.
Actually, China iPad is not basic. Is not due to it's actually transfer of rights that the assignment document was not really.
Yeah.
One of my friend represented the case.
Uh-huh.
But I think nowadays, because I
Yeah.
extensions are so popular and it's not really something you can prevent. So sometimes if one has a monopoly on something, I guess it comes with a price. Anyway, we can talk more about registration, trademarks, or everything. I think you had a question in terms of it's gone. Okay. Oh, what I wanted to just mention about defending and design around cost is actually a major deal breaker in a lot of litigation cases, or in a lot of licensing cases, or even in a lot of patent technology sales context. Why? Because design around could cost you heavily, and sometimes it could cost you really great deal of time and money. So in order to actually catch the timing to, now we have 4G, next year we have 5G. In order to catch the timing, you may as well pay this pool of patents and technologies instead of designing yourself in-house, because sometimes it saves time, and time means returns, revenue, right? Grouping we already talked about. So next, okay, so how do we maximize that? Now we get into the exciting part, hopefully not yet sleepy. So first of all, you have to mine your IP assets. If you don't know if you have any IP assets, then how can you maximize the value? How do you mine it? You look at your process. Is it unique? Is it innovative? Is it novel? Is it not so obvious? If it's novel, non-obvious, and actually have utility, have use, then you could be subject to US patent protection. And if that's industrial usage, or if you satisfy many other criteria, you can be protected in China, in Hong Kong. And Hong Kong has a quite easy protection system by way of filing in China or UK Patent Office, or your EPO, the European Patent Office. You can actually register in Hong Kong. So that's first step. And also look at your name. If you have a trademark, if you want to symbolize your product, almost every product needs to have some sort of a symbol or name. Otherwise, how can you identify your goods? So you always want to register it. Well, obviously, I already talked about protection. Now, after you have protected your IP assets, next step to think about is to maximize the value of your IP assets. How do you maximize the value? Obviously, we talked about app earlier. So some apps are not really protected by patents, but they are probably protected by copyrights, sometimes trademarks, or but by the presence, vast amount of users on the marketplace, their value goes up. Again, goodwill, presence brings value. So just 3 examples, P&G and Intel, and how much money they derive from licensing just their brand names. So if we see all the P&G products, they don't have to do anything. They just collect money from licensing these names. Wouldn't it be good if anybody can create a business as such?
The game Candy Crush, is this patented?
Candy Crush?
Candy Crush. Do you know it?
Yeah, I know lots of people are playing it. I doubt it's patentable, but I may overspeak. I need to see. I don't know. I never searched if it's patented. But most apps are not patentable because they are basically algorithms. Now, previously in the US, the patent law was more lenient. So we had a lot of business method patents and financial methodologies, a lot of models like Wall Street using to trade equities, trade bonds, and also many kinds of process or business methods were protected under patent. But recently, about 1.5 years ago, there is a Supreme Court case called Alice. In short, we call Alice case. Not Alice in Wonderland, but Alice in a disastrous land, that actually cracked down a lot of financial industry patents and business method patents. So like eBay, when it started business in early 90s, late 90s, early 2000s, it patented the reverse bidding process. So many companies actually sued because it's not patentable. Auction is a traditional way of doing business. Why should they be allowed such rights? Well, eBay argued this simply because we are actually reverse the process. We are not using the traditional way of getting a goods, but our process is actually backed by very sophisticated algorithms and carried out by a series of machines, devices, apparatus. So it's patentable. Anyway, so the recent case is Alice actually cracked down a lot of financial industry and business method patents. But still, we can get a lot of granted, well, obviously subject to very good lawyering skills, but also if you have a good innovation, if you have a good invention that's actually not a traditional way of doing business, then it could be subject to patentable subject matter. So it's not to say it's more stringent, but it's not impossible to get granted patents for these games or apps such as Candy Crush or whatever, Saga, or all of these games.